Good afternoon and welcome everybody to Colorado's second Virtual Connect, our Wednesday webinar series, which is new to you in these strange and unique times. I hope you're all settling into some kind of new routine that we have going on. We decided for this one, and if you were with us last week, you heard us talk about how we want to interchange between more of a community conversation about what's happening amongst the profession with our members around the state, and then intersperse those with some HSW credits. And so this is the first of our HSW offerings. We know that you still need that content and that continuing education to maintain your licensure and to maintain your skills as a technical professional. So that's what we're starting with today. And we thought we'd bring back an oldie but a goodie. I'm not talking about the presenter, I'm talking about the subject matter. Pandemics and project schedules. No, actually, this is fresh content with relevant insight. Very timely for the situation we're in, but using some legal precedent from some other things that we've experienced as a profession and as legal entities here in the state of Colorado, serving the design and construction industry. To do this today, we've got one of our dearest friends and greatest advisors on our policy. Before I introduce our speaker though, I want to let you know that we are going to take questions in the second part of this seminar. The way to do that is to go to the bottom of your screen. There's a Q&A function. So if you click on that bar along the bottom for Q&A, it should bring up a dialog box for you to type in your questions. I'll be monitoring those as they come in, so they don't appear to everyone. We'll just see them as they come in. As you think of a question, put it down. You don't have to wait until we get to that Q&A portion. And then when we're ready for that, I'll start feeding them to Phil and he'll be taking them away. Then at the end, we're going to have you use the chat feature. To get your HSW credits, you do need to stick around to the end of this presentation today. So we'll give you instructions at the end on how to receive that credit. So without further ado, I want to introduce Phil Cardi. Phil, as I said, is one of our longtime partners on a lot of platforms, but his day job is as managing member of Cardi, Schulte Ford. And since the late 80s, his practice has emphasized representation of architects and engineers in design and construction defect cases, also in risk management and drafting and negotiation of contracts. Besides the usual bar association memberships, he's a professional affiliate member of both our organization and the Association of Geotechnical Engineers, and he does a lot of help advising the ACEC of Colorado with their Legislative Affairs Committee. He's a past award winner of both us and ACEC for being an advisor on amicus briefs. That Supreme Court case basically took up his argument on our behalf that economic loss is not subject to architects and engineers. It's a different scenario than what we're dealing with today, but somewhat related. You'll hear more about that later. And he's also helped us write legislation to have an anti-duty to defend clause for architects and engineers in their contracts, which passed the legislature back in 2015. Phil, I don't know if you're still working on your golf game right now. It may be on pause, but he likes to spend his free time doing that, along with his wife and Marty with their 2 children. So Phil, welcome to our live from home audience. And we're so thankful you could help us tread this new territory today. Take it away.
Thank you, Mike. Can you hear me?
Yes.
Okay, great. Welcome everybody. I appreciate the opportunity to do this. I think this really is timely. I've been fielding calls this week about the various situations that design professionals are facing because of this pandemic. I've had a few questions from architects, engineers, and contractors about not only what are they obligated to do, but I've had a few people that maybe come from the right side of the political spectrum wondering whether or not the state even has the authority to issue the orders that they've been issuing. So obviously very pertinent topic. And what I tell people, and what I want to talk about today, is what you need to do, first of all, is in a situation like this, look at the deal you made with your client. That is the contract. And so I'm going to try to share a screen here in a moment. But the bottom line is, when you're wondering, sitting around your office saying, well, how do I service this project with these restrictions in place? I think you need, first of all, to go to your contract to see what are your obligations. Your contract is essentially the private law that you agreed to with your client. And if you go to that contract and look at your obligations, then you can start to map out a strategy. How am I going to fulfill this? And if I can't fulfill it, how am I going to deal with that? So the first thing, obviously, is look at the contract that you have on a given project and understand where you are in the delivery of those skills, or excuse me, those obligations. And sometimes your project will be, well, I'm losing something here. Hold on a minute. No, that's not it. Often you will be in the design phase. And if you are in the design phase, typically you can continue with that unless you have an owner who has said, golly, I don't know that this project is going to be feasible economically or financially when we get to the end of completion, and they may want to put the project on hold. If you're in the construction phase and you have construction phase responsibilities, then you have essentially a different set of questions, and you have to look at your contract and look at what you are able to do. So I'm going to try to share a screen here. Can you all see this screen?
Not quite yet, Phil. I think you just need to press the share at the bottom.
Okay, let me see what I've done here. Share screen. Here we go. Okay, got it. There we go. Can you see it now?
Yes.
Up on the screen should be a standard clause from the AIA B101 Owner Architect Agreement. Are you able to see that?
Yes, yep, that's up on the screen.
Okay, so this is straight out of the AIA Owner Architect Agreement. And what I've done is highlighted the language that is relevant to just the overall question of delays. If you have to stop your services or they're slowed down because of the difficulties of working remotely, perhaps there are individuals or consultants that are involved in the project who are indisposed. Maybe they have the illness. Maybe they're not able to get to the technology that they need to complete their work. In any event, so this addresses delays. And so if you see, if you look at this clause, it says, to the fullest extent permissible by law, the architect shall indemnify and hold harmless the owner. And it goes on to talk about under what circumstances you will be obligated to do that. Well, the good news is this language says you're only obligated to indemnify the owner if the delay is caused by the negligent act, error, or omission of the architect. Well, getting sick is not negligent. And if you have a sort of, well, if you have an order in place that you have to stay home, whatever, and can't get the work done, obviously that's something outside of your control. Now, having said that, you do need to understand, what do the orders actually say? I've talked to a number of people who have said, well, we're all supposed to stay home. And they've said that without reading the state's order. And I encourage you to do that if you haven't. It's available online from the Colorado Department of Public Health and Environment. And it outlines who can continue to work. And it is a surprising document because, frankly, it's Swiss cheese. There are so many exceptions to the stay-at-home order or shelter-at-home order that, quite frankly, there's probably a loophole that you could use to justify continuing to work if that's in fact what you wanted to do. Or conversely, it is something that your client could point to and say, see, you didn't have to be at home. You could have done the work. So this is something that is going to require careful review and communication with your client. One way or another, you have to communicate with your client and figure out what it is you're going to be able to do or not do. So if we look back at the contract document and you see this, again, this is straight out of the AIA, B101, and it relates to schedule. And this is a clause that talks about how the schedule is established, and then secondarily, whether or not or under what circumstances you'll be able to exceed or deviate from that schedule. And as you can see here, the language in bold says that the time limits established by the schedule shall not, except for reasonable cause, be exceeded by the architect. So again, the AIA has built into the standard agreement language that gives you an out, that allows you to say to your client, well, there is reasonable cause here. This is an unprecedented situation, and therefore, we are entitled to contract extension or whatever the relief may be, or the modification of your agreement may be. But it's really important that you talk about it. And once you've talked about it, whatever the resolution is, that be documented. Whether it's a document that's signed by everybody, that's less important than just having it in writing. And exchange in a communication, whether it's email or whatever. So if in fact your services are extended, let's say, for example, that a project is in construction and the construction phase is delayed by a couple of months, and you have additional construction phase services. A lot of people like to say CA services. I don't like that term because people call it construction administration, and I don't like to or suggest that an architect is a construction administrator. Obviously, that's a term that is shortened from the AIA language, which talks about administration of the contract for construction. But in any event, that's an aside that's just a pet peeve of mine. So this gives you also not only a right to alter your schedule, but if in fact somebody else has altered the schedule, that is, the contractor has taken more time, or there is a problem with the building department, whatever, and you have to provide extended services, this gives you the right to ask for add services. Not sure that owners would be particularly thrilled about that, but in fact, that right is there. So one of the questions that I have had in recent weeks is, well, what do we do about the contractor? What if the contractor is dragging his feet or is doing something that's going to extend the schedule? What if you're not able to get to the site to determine percent completion? In any event, all of these things are going to perhaps impact your obligation during the construction phase to act as the initial decision maker regarding contract performance. And the AIA contract, again, talks about your obligations to provide those services and what you're going to do and what standard you'll be held to. In 3.6.2.4, this talks about interpretations and decisions of the architect. And it isn't just about performance of the contract and the intent of the contract documents, but to the extent, for example, that you have to determine whether the contractor has performed the work to the percent completion that he said is indicating in his pay application. These are things that you're going to have to decide, and you're going to have to do it in an impartial manner. And if you look at 3625, that's on the screen, again, this is a clause that talks about the architect as the initial decision maker, as that term is defined in the A201 document, which is the general conditions. And you'll end up having to render initial decisions on claims, and that could be claims for delay, claims for extended general conditions, claims for any manner of relief under the construction contract. It'll usually be a request for more time or more money. But again, these things will be more prevalent, I think, in this climate with, frankly, goodness knows what's going to happen with vendors, with suppliers, subcontractors, etc. The good news is, frankly, that the state's order regarding the stay-at-home requirements has an exemption for construction. That is somewhat odd to some people, but it in fact is there. And it has an exemption for professions and services which are supporting construction. So there is an interpretation available of that order that would allow design professionals to continue to work. Another aspect, as we talked about, we talked to an architect in the last couple of days who has laid some people off because the work they're doing is mostly multifamily for rent, in other words, apartments. And the owners are concerned that they're going to get to the end of construction and there's not going to be a market for their apartments. And so they have asked the architects to suspend design services. So these two clauses from the AIA document are pertinent to that particular event. Depending upon the amount of time there is for suspension, if it's more than 90 days, you can terminate if you want. Either way, if there is a suspension, you're entitled to compensations incurred in the interruption and resumption. Proving those up is not always easy, and I suspect that many owners are going to be unhappy about being asked for that. But the fact is, it's in the agreement, if in fact you've used an AIA document, and you're entitled to something. At a minimum, when you're entitled to something like this per your contract, it's something you ought to raise because it becomes a chip that is useful for bargaining when other issues, maybe on the owner side of the table, come up, whether it's alleged design errors or delays, omissions, etc. Sometimes those things can be traded. So understand that those clauses are there and are relevant to this particular situation. If we look at the construction contract, and again, this is an AIA standard agreement, A101, and I raise these issues because you are, as we've discussed, often going to be administering the contract for construction and making decisions about contractor performance and owner performance for that matter. So what happens if there's a delay? The contractor's contract 5.1.8 indicates that if there is a material delay through no fault of the contractor, the contractor is entitled to additional compensation. How that's measured will obviously be the subject of discussion, negotiation, and probably falling back to original proposals, bids, etc., to determine various rates of expenditure, if you will, for a day, a week, a month of a construction period. The AIA 201, the general conditions, talk about delays that are the result of an act of the owner or the architect, or other causes beyond the contractor's control. Now, it's interesting here because what this says is that the relief the contractor will get if there are causes beyond his control that delay the project is an extension of time. It doesn't say anything about money. It doesn't say anything about extended general conditions or whatever the cost the contractor may be seeking. And of course, the contractor having extra time is good, at least in many situations, but it may not be all that the contractor wants. The point here is, though, that the contract in and of itself doesn't necessarily determine what those amounts will be. And I've inserted in here at the end of this page a reference to Article 9 with a question mark. Article 9 goes on for several pages, and unfortunately, it doesn't really say what the contractor will be entitled to in terms of additional amounts as referred to in 5.1.8. Again, this will be a matter of communication, negotiation, etc., mostly between the owner and the contractor, but I'm sure that these questions will involve the design team. Last thing that I wanted to talk about before we get to questions and discussions of your particular issues is what is called the force majeure clause. A lot of people throw that term around as if it is standard law, accepted law in the United States. And the fact is, it is not. It's a French term, and it, in general, refers to matters outside of one's control. And it is something that is used in those countries that were either French colonies or parts of France. And it has been imported into certain construction contracts, but in general terms, none of the AIA documents use the term force majeure. Many construction contracts do use the term. The bottom line is, in Colorado in particular, but also anywhere else you're working in the United States, a court is more than likely going to look at the specific contract terms to see whether somebody is entitled to relief from a schedule because of this pandemic that we're dealing with. Now, I do believe that most courts will not be particularly rigid about schedules under the circumstances, because the things that are happening are so unique, so unusual in our collective experience. But if you have a lot of money on the line and people arguing for strict enforcement of the contract, well, it might happen. In this particular clause, this was a contract that I saw come across my desk. Client submitted it to me for review and comment. And this was a local metro area county, and they actually have a force majeure clause in their owner architect agreement, which I thought was a little unusual. And it in fact talks about epidemics and quarantines, which obviously we have here. But if you had a force majeure clause that did not say that, did not use those words, there would be a potential debate about whether or not this clause covered the kind of events that we're seeing. Again, courts are generally inclined to enforce whatever deal parties have made in their contract. And if the contract does not talk about epidemics, quarantines, or some other event that, or use language that can be stretched to fit what we're going through, the contract may be found to provide no relief. And so it's important, not only if this is in your contract, but if it's in a construction contract that you are administering, it's important to look at the language and see whether or not the situation is covered by the contract language. So one of the things that I wanted to talk about, we talked about the fact that whether or not your contract addresses a situation is really the first question you need to ask. The first place to go is look at your contract. If in fact your contract requires that you provide a service that you can't provide under the circumstances, or a more difficult issue is it requires you to provide a service that legally you're allowed to offer. In other words, let's say you have a project in Utah, and you're required to fly to Utah to provide or to perform the site visits that your contract says you should do every 2 weeks. Well, perhaps you don't feel like traveling. You don't think it's safe. It's just generally something you've decided, well, I don't want to do this. I don't want to put my health at risk for this project. However, the contract says you're supposed to do it. And you can, in fact, travel. Airline tickets are real cheap. There are hotels and rental cars available. So what do you do? In that particular situation, I think you have to communicate with your client, and you have to document your decision making. If you've decided you're not going to make the site visit, you need to put that in writing so that it's part of the record, so that at a minimum, when the project's done, and let's say there's some deviation or some issue with the construction quality, and the owner wants to hold you accountable for that, it would be very important for you to have on the record a statement that you were suspending your site visits at a given period, and will notify the owner when you start your site visits again, so that it's documented you were missing the project for this period of time, so that the owner can't say, well, you were on site, whatever. Now, maybe you should have been on site, and maybe that's what the contract requires, but that's a separate argument. If you've decided that, no, I don't want to service this project in that way because of the health risks, that's something you need to document. Obviously, I should add, it's important that you get your owner's, your client's concurrence with your decision. If he objects, if she says, no, you've got to do this, then you've got another decision to make. And that is where perhaps maybe you need to get some legal advice. Certainly, that's something that needs to be thought through so that you understand the various consequences or potential consequences of the choices that you make. Let me see, I'm going through a list of things here that I talked about. One of the things that is a concern, I think, in these times is the risk of compromising the quality of service, whether it's coordination of design disciplines in the design phase, which requires obviously working with your consultants. If it is, again, a construction phase service, such as a site visit, or such as review of the contractor's application for payment. If you're not making site visits and you don't know what material, equipment, etc., is on site, it's difficult, obviously, to do that job. It's important that you not compromise what you're doing unless you're making it clear to your client and documenting it that there is a compromise. In other words, if you're not able to go to the site to see how much is complete, etc., then that's something that needs to be identified to the owner so that he can make an informed decision about whether he's going to make the full payment that is in the application for payment. Those are the issues, again, they're difficult, but they need to be discussed so that everybody understands and there's no questions later or potential for questions or accusations later that the owner was not informed. So it's again important not to compromise quality, to identify for everybody concerned what you're not able to do in these unusual circumstances. So with that, let me see, where are we? We're at 2:36. I'm ready for questions or comments, discussions, concerns.
All right, well, thanks, Phil. It's covered a lot of ground there, and we've got some questions coming in already. I think you covered a lot of the ground that we thought might be covered. The first thing that comes to mind, though, you know, an architect has a duty of care not just to the owner and the project, but to their employees as well. So even if architecture is defined as an essential service and access to the site is not ordered to be limited, what about those firms that say, you know what, we have made a decision not to put our employees at risk? If the owner comes back and says, we had to stop or delay the project because the architect wouldn't show up, how do they deal with that scenario?
Excellent question. I think it's important to have that conversation with the owner. Now, if the question is, what if the owner says, well, I don't care about the health of your employees, I've got to get my project done. In that event, quite frankly, I would like to get that kind of sentiment, that expression from the owner in writing. I believe that, again, the architect's responsibility first and foremost is for the public safety and welfare, to protect the public safety and welfare. Now, if your client wants to proceed, for example, with the project, notwithstanding the fact that you don't want to continue services, then I think it is the client that's creating the risk. I agree with, and maybe it's not stated, but if in fact it is felt or decided by a particular firm that you cannot provide the services without creating unreasonable risk to the employees, then I think you're okay with that decision. I think that's an acceptable decision. I think it's defensible. And ultimately, I believe that what a court would probably say is that there are certain risks when somebody undertakes a commercial enterprise, such as building a project. The person who takes on those risks starts out as the owner. Now, he tries to transfer risks to various people through his contracts, and of course, design professionals accept some of those risks, but those risks are very limited. And something like this, I don't believe an architect has assumed the risk of essentially making his employees sick and perhaps causing them severe injury or even death by making them work. So I think the decision to act cautiously is defensible, but I do believe that it needs to be an upfront, or excuse me, out in the open adult discussion, as opposed to the way a lot of decisions are made, which are, well, I'm going to try this, I'm not going to talk about it, and hopefully the owner won't say anything. I think those things have to be discussed out in the open.
In that discussion, is it helpful for the architect to reference stay-at-home orders or CDC guidelines or something? So it's not just, I mean, we understand that everybody's got this circumstance to deal with. Potentially helpful to not just say, we made an arbitrary decision here, we're basing it on this guidance elsewhere. Even exempt from an order saying we can be there, we're still an abundant caution or just a reasonable calculation saying we're not going to have our employees subject themselves to that.
I think absolutely it makes sense to do that. Now, as I discussed earlier, there are a lot of loopholes in Colorado's version of the stay-at-home order. However, those loopholes are really intended to serve an essential purpose, whether it's a healthcare provider, somebody who provides foodstuffs like the grocery store. I mean, we don't live on farms anymore. We get all of our food at the grocery store. If you're not working on a critical project that must be up and running to protect the public health and safety, then I think you're justified in relying on those orders, and I think they can be cited. Even if the owner comes back and says, look, there's these loopholes, etc., I think you can take that debate quite a ways using the orders.
So it's ultimately that the employer's discretion as to how they employ their employees.
I believe so. I believe so.
Can a firm suggest alternate means of meeting those contract requirements? For example, you know, before this pandemic, a lot of these were done with boots on the ground. Is there a way to suggest we'll get eyeballs on the problem, if not physical presence?
Certainly. I don't know, the hypothetical that you're posing is, I guess, lacks some definition. I mean, I don't know exactly what the details would be of a given situation.
Well, I'm trying to think, instead of saying,
I had this conversation with a client.
Instead of the client saying, you need to be here, and the architect saying, we don't think it's safe to be here, is there something in between that could be suggested?
Sure. For example, if the owner believes it's safe to be there, then I think what you do is you say, okay, Mr. Owner, why don't you take some pictures and send them to me, or do a video and send them to me, or have the contractor do that, since he's already on site and has exposed himself to whatever conditions are there. That's just one example. In talking with a client who's got the project out of town, out of state, and the question about making site visits, I asked the question, well, architects are, a lot of folks are concerned about workload. They're looking for work. Maybe this is time to hire that local architect to go make the site visit.
Yeah.
That's a possibility. In many situations, it's not really feasible because project's too complex. It's already too far along for somebody to get involved, and perhaps they wouldn't want to take that risk either. But that's again an option. Alternative means of performing the contract, again, make sure it's an agreement that has been discussed in a manner that can be proved later. It's not something that should be done just by telephone or an oral conversation face to face, even if it's 6 feet apart.
Yeah.
Be in writing.
We're hearing from some client sectors that they're even expediting projects, taking advantage of the fact that their sites are empty, their buildings are empty. And so that's an interesting one that needs to be considered too.
Yeah, I don't know what the building departments are doing. I think that is a real issue for construction, for projects in construction. I'd be interested to know what the membership says in terms of their experience with getting inspections, if you know, in the last several weeks. Has that been easy to do, impossible to do? What has been happening?
It's been jurisdiction by jurisdiction, basically.
Yeah.
City and county of Denver are still fully functional, but that's probably not the case in a lot of other places. And I think most of us who deal with these departments know that the folks that do most of this work, as you know, inspectors, site inspectors, and plan reviewers, are at the older end of the spectrum. So they may be allowed by their employee to do the work, but they may have personally chosen not to, you know, engage in it.
Exactly. There's going to be a lot of that case by case situation, I think.
You mentioned the situation about a hypothetical project in Utah. Since we don't have a federally declared, you know, stay-at-home order that applies across the board, it really is left to governors and mayors to make those orders. If you've got a project somewhere else, like, so let's say there's a person whose residence and office is under a stay-at-home order, but they're working somewhere where that mayor or governor has not issued this, and that's systems go.
I think in that scenario, the more restrictive order would apply. Somewhat ironically, like the question of a conflict between plans and specifications. The usual rule is that the more conservative, the more stringent would apply. When it comes to protecting health, I think the more restrictive order would apply, if you wanted to.
So while access to that particular job site may be unlimited, you know, according to the local authority, the access to the workforce, which is located somewhere else, might have been limited by a different authority.
Exactly. And I think, again, if Colorado is more restrictive than, say, Arizona, just to pick another one that actually did not have an in-place order until very recently, I think a Colorado architect serving an Arizona project would be justified in following the Colorado order. Again, it's something to make sure that it's been documented, that you've told the owner that's what you're doing. So that he's not there assuming you're making site visits when in fact it's not happening.
Well, and the owner, it's not a burden of the owner to know what your local jurisdiction is said about.
Exactly.
You know, they only care about where they're located.
Right. That's right.
You talked about modifying schedules on existing projects using the AIA contract documents. Is there anything architects should be including in contracts for new projects that are starting up?
That pertains to
well, like that, maybe that metro area county clause, or to say if access to job site is limited by, you know, a public health order, or access to our office is restricted.
Yeah, I believe, frankly, I was surprised because when I went and looked at the AIA documents with this pandemic situation in mind, I was surprised that the language was broad enough and flexible enough to deal with many of these situations. That said, as I said, I did a search in the B101 and the A201 for the words epidemic and quarantine and disease, etc. They did not appear. So to answer the question, I believe using the language from that force majeure clause from the county contract that that was in on screen is a very good idea. I don't know that you need to call it force majeure. You can just say in the section that talks about schedule and relief from schedule, make sure that those things that are identified there are included in your contract language. I think that's very helpful.
Yeah, that's a great suggestion. And it's even better that, you know, it's not being created from whole cloth. We can, again, cite another jurisdiction that's already using this language and has contracts in place.
Right, right. For everybody out there, that came from Arapahoe County.
Okay.
So
if someone, it would be great if everybody used the contract documents that AI produces, but of course
right.
that's not the case.
That's right.
What about, like, say for example, the Office of the State Architect? If you got one of those contracts, or someone that's not using a AIA standard form of contracting, they need to look for it. What are those? I mean, they probably won't have it in a search function on their computer, but as they're going through those other what are they looking for the same things that AIA has identified in their contracts?
I believe so, and I believe the language that you want to look for is very similar to what we saw in the AIA document or that Arapahoe County document. You know, I should have looked at a state architect contract in preparation for this. I did not, but it's usually, my experience has been it's a good set of documents, and it's a pretty fair agreement as well. So I suspect it does cover the situation, but if it does not, I would certainly bring it up and raise the issue, because I think, frankly, the state is in the same boat.
Yes.
They're trying to figure out right now, golly gee, does our contract deal with this situation? And you know, how do we handle, whether it's a contractor that's asking for more money or somebody who wants to suspend services, whatever. I'm sure they're having the same issues, you know, as an owner with a lot of projects going on at any given time.
What if an owner is just non-responsive? So you've made a determination. You don't want to suspend the project on your part or cancel the contract. Walk away. Might have some risk to your employees by going on job sites. And you try and initiate that conversation to modify the contract or get an agreement in writing. And there just isn't a response back.
Just total silence?
Yeah, I mean, who knows what they're dealing with? Everybody's world's a little crazy right now.
Yeah.
Is your reaching out in writing, even by email with a timestamp on it, sufficient to say we tried to communicate how the expectation of our delivery of services will go from this date forth, even if it's not reciprocated or acknowledged?
That's where you start. Is you start with written notification to the owner. This is what we're going to do, and this is why we're going to do it. And then, if you don't get a response, again, then I think the thing to do would be follow up and document. We communicated with you on, you know, March 23. Here it is, April 1. We haven't heard from you. We're communicating with you again. Not having heard from you, we've decided that we're going to do this. Now, what I would suggest is that if a design professional is going to make that decision, you have to think ahead and notify, say, a contractor, a building official, whoever, who may need to know that you're stopping services, so that you are not going to be providing a function that one of those two may be not necessarily relying on, but certainly expecting. So you need to give notice to, you know, others as well if you've made that decision.
And a similar, totally different, but the same thing would apply on you know, payments. So some of these folks might they may have made a decision, or they don't even know what to do about whether to stop a project or not, and they've stopped responding to your request for invoicing. Is it worth considering things like, so how would you document, we worked up to this date, whether the owner stops it or you just decide we got enough of a productive relationship with our client at this point to know whether it's going to proceed?
Well, if you're having trouble getting paid, that's always obviously a difficult situation. Hopefully your contract gives you the right to suspend services. The AIA documents do, in the event you're not getting paid. And obviously, after a certain point, it gives you the right to terminate as well. If the owner is not communicating about payment one way or another, in this particular climate, when everybody's getting stretched in terms of cash on hand, because people are going to be slower to pay, money's going out, it's not coming in, kind of thing. I think it's really important that you manage your I want to call it accounts receivable. You don't want to get too, you don't want to get too far ahead. Don't assume an owner's going to be reasonable, because this is just an unprecedented, unpredictable time, and I don't know what's going to happen. I don't think anybody does. So stop, document. We've invoiced you for services through X date. If we don't get paid, we're going to have to stop, because fees are how we keep the door open, so to speak.
Well, you said it in a word. These are unprecedented times, but it makes me wonder, so much of our legal system is built on precedent, past practice. Is there any precedent out there for a situation like this?
Well, yes, not in the sense of recent precedent, for sure. There are, obviously there was the Spanish flu, but that was a century ago. I haven't looked, but I bet there are cases that have arisen from the polio epidemic that was so scary in the 40s and 50s. There were also episodes of tuberculosis and other communicable diseases. Obviously, those diseases have been suppressed through modern medicine for so long, but I'm sure there is precedent. Again, that's why contract language is so important, because the courts, rather than trying to decide these issues by playing Solomon, they want to be able to rely on contract language, which is, again, it's the agreement the parties made, so it's easier for the courts to justify their decisions that way.
Yeah, and a court is not going to rely on precedent to overrule something that's explicitly written in a contract.
Correct. That's really, it happens, but not very often.
Right. It's a rare.
So it's best to make sure that your contract is in good shape, make sure it's signed and all of that. But obviously, if you're creating the document now using this language that gives everybody flexibility to deal with these potential risks, is really important. And that's the way the courts look at all these things, is who in the contract assumed the risk of a particular thing happening, or not happening. So
who agreed to what?
Exactly.
Yeah. Well, if I was more sophisticated on my sound effects, this would be the time that we would have an applause track playing for you, Phil. Really insightful conversation today. And before we leave, I do want to ask our attendees, if you could use the chat feature. This is the part where you get credit for listening to all this great insight today. If you could use the chat feature, which again, it's on the bottom of your Zoom window, and put in your member number. So use the chat feature, type in your member number, and that will be the way that you'll get recorded for attending this seminar and getting your credit on your AIA transcript, and then you can use it for your DORA renewal or HSW credit as well. And while we're doing that, I want to do another couple of housekeeping items. We have recorded this webinar. It won't necessarily be available by video, but we'll have an audio recording. So if there's something you heard and you didn't take the note down quick enough and you want to refer back to it later for something said that sounds like a good tip or idea you want to follow up on with your client or your employees, you'll be able to access that later. Megan can help you get that. Megan Concanon in the AI Colorado office. We also have more virtual connects coming up on our calendar. Next week on Wednesday, we're going to be having a panel hosted by our local section directors on the AI Colorado board to have a town hall discussion on what's going on around the state in our various sections and talk about ways that we can serve you better on the local basis. I hope everybody has a great rest of the week. Watch our calendar. We're continuing to populate the events section there with ways to deliver engaging content to you. And then if for some reason you want to get credit for this and you didn't have time to get your member number out, please contact our office. Again, that's Megan Concanon at AI Colorado. Get yourself recorded.
Thank you, everybody. I really appreciate the opportunity to do this.
Thanks again, Phil. Everybody have a great rest of the week.
You do the same.
We'll leave the chat function open for a while so people can continue to type that information in. Thanks.